Ready, start. So, to our view, non-collection of blood-stained cloths of witnesses or knitting of the court is not fatal to the prosecution. Full stop. This apart, it is evident from the record that the FIR was lodged promptly and the investigating officer had prepared the site plan along with other connected papers forthwith. Full stop. He had recorded the statements of the witnesses so merely on the ground of certain shortcomings, it cannot be said that the entire investigation was defective or tainted. Full stop. It is a settled proposition of law that merely because there are some shortcomings in the investigation, entire prosecution case cannot be thrown out. Full stop. It was held that the defense could not take advantage of shoddy investigation when there was clinching eyewitness account of the crime. Full stop. It further went on to hold that benefit of doubt cannot be extended to the defense merely on shoddy investigation when otherwise the witnesses of fact had stood their ground, and it went on to affirm the findings of conviction. Full stop. In all these cases, the Honorable Apex Court has propounded the principle of law that to fulfill the requirements of Section 300 IPC, it is required that the bodily injury must be intended and the bodily injury intended to be caused must be sufficient in the ordinary course of nature to cause death. Full stop. This clause is in two parts, colon dash. The first part is a subjective one which indicates that the injury must be an intentional one and not an accidental one, semicolon. The second part is objective in that looking at the injury intended to be caused, the court must be satisfied that it was sufficient in the ordinary course of nature to cause death. Full stop. In all these cases, the facts are different than one in hand and are of sudden scuffle or there was no intention to kill. Full stop. In these circumstances, the Honorable Apex Court has propounded the above principle, but these decisions do not help the defense because the entire matrix as stated in the above cases are different to that of the present one. Full stop. In this case, the very genesis of the case commenced a day before the occurrence when the accused Janardhan Singh had beaten the younger sister of the complainant on the pretext that her goat had entered his field and the complainant and his cousin brother Ram Pravesh had gone to protest when there were heated arguments between them and the accused persons had threatened them with life and on the very next day, they got the chance. Full stop. Virendra Singh had exhorted to kill the complainant and deceased Ram Pravesh, whereupon Janardhan Singh stabbed the deceased Ram Pravesh on the chest, which in ordinary course was fatal, and Ram Pravesh had died on the spot. Full stop. The nature of weapon used, seat and nature of injury are also relevant to reach such a conclusion. Full stop. Even PW-7 Dr. B.L. Gupta has stated that the blow given by the accused Janardhan Singh was sufficient to cause death in the ordinary course of nature. Full stop.